And good afternoon, everybody. This is Vinny Maletti with Maletti Law, the strongest name in law. First and foremost, before we get started, please make sure to click like in the video down there and go subscribe in that little red tab so you could always get notifications for updates, everything that we do here at the firm. Make sure you go to the website, www.malettilaw.com, www.malettilaw.com, and sign up for the newsletter. You always want to be in the know. You never want to be missing anything. We do a lot of cool things, offer a lot of free content, so certainly don't miss out. All right, so you'll notice the environment in this video. I am in my wife owns a gym called The Fit Life with Dawn. We are in the studio today broadcasting because I happen to have a mascot who is a very naughty boy and doesn't want to give me 5 minutes to make the video. And every time I try to make a video, he bites his squeak toys and he likes to bite the cameras and everything and be very distracting. So I decided I'm gonna have to do this. I'm either gonna have to put like a barrel in the dog's back and make the dog go run away, or I'm gonna just do this from the garage. So whatever, I'll do this from the training studio here at the Fit. Okay, so let's get down to it. So the purpose of this video is like I have three videos actually coming. 2 videos that I want to actually do today. That they're very helpful. They're very practical for your purposes. I found it very practical. So let's go through the scenario. So scenario is you have a client and you want to file a motion for injunctive relief, or you want to file an order to show cause and you need injunctive relief. Those are a lot of big fancy words. So let's just explain that. A motion is just is you're asking the court to do something. It's a formal document in which you ask the court for injunctive relief. An injunction is an order granted by the court. Relief is you want certain kind of relief. So a motion for injunctive relief is you're preparing this formalized document that you're asking the court to make a ruling to give me relief. Now, an order to show cause is a similar vehicle, just it functions a bit different. It's generally faster, and you could usually, for an order to show cause, you can usually use what's known as a restraining order in that language. So basically, it's about haste. An order to show cause is really about haste. So you need it quickly, you want it fast, and order to show cause does that. Order to show cause is generally a lot quicker than the motions. You also, if I remember correctly, you can, I think it's section 202.7 or G or something like that, where you could request for a faster motion. I can't remember off the top of my head, but there's like order to show causes that are just quicker. All right, so and they have you could put a temporary restraining order in there, so be a little more aggressive. Okay, so you have the terminology. So now you want to ask the court to do something for your client because you want to prevent your client from suffering. You go to the court, you end up losing your motion, the court rules against you. It doesn't give you really any reason why, but the court rules against you. So there are 2 tools that New York has if you want to bring this argument again. I mean, generally, no judge is going to want to hear the argument a second time, right? So they're not going to grant that. You already have a decision, that's it. But there are 2 systems in place. There's 2 tools that New York generally has in the CPLR, the Civil Practice Rules and Laws. I don't know whatever CPLR stands for. It's you just get used to saying CPLR that you never actually think about what it is. So civil practice law and rules. The civil practice law and rules. Okay. So you file the New York CPLR has 2 tools that you could use. You can use a motion to re-argue and a motion to renew. They're both available under CPLR 2221, CPLR 2221. And in one instance, you have a motion to re-argue, which is in that situation, you're telling the judge that they misapplied a law or missed something that was already on the file, and they need to get another shot at the apple. The second instance is called a motion to renew. A motion to renew is when you come across some new information after the fact, or something that wasn't readily available before, and you bring it into the judge, and you say, hey, listen, these new things happened. We'd like to renew it on the merits based on what's going on here. And they both have their strengths, right? So I mean, like, you could combine them, but then I personally think that that's probably not a great idea because, you could argue in the alternative, but, these 2 things ask the 2 very specific things, right? And one of them you're saying that in the motion to re-argue, you're saying that this wasn't in the file before, and with the motion to re-argue, you're saying that all this stuff was already in there already, it should have been clear to you, but for whatever reason, it was misapplied or was misconstrued or something was missed. So that's a very different argument than saying these new things happened, therefore we need to renew this, you know? So a motion to renew will come up in situations like there's a new law in the books, there's new facts, new data that came across, or whatever the case is. Those are those are usually the two pivotal things. In my situation, it was that new facts came up after, so we made a particular argument for an injunction. Our argument for injunction failed. There was no particular reason why our argument for injunction failed, but as expected, the acts that occurred after that injunction failed reflected what we suspected would happen during, giving rise to the reason why we wanted that injunction in the first place. So, I mean, on its face, that's a clear textbook explanation of, how generally a motion to renew works. Long story short, in our situation, we had new facts and we wanted to file. We filed and kicked them out. And now we currently have that in place. So obviously the expectation is, based on these new facts, do we meet the criteria necessary for an injunctive relief? So, I mean, that's obviously going to be up to the judge. That's obviously the judge's call right there when it comes to that. I mean, we obviously think we do, the judge may not, who knows. The point is, the real purpose and strength of this video is just giving you all an idea. So it's not the end. Remember, just having your injunctive relief denied, having your order to show cause denied, whatever the case is, that's not the end of the road. There's still plenty of avenues you can go to. It's still so early in the case, and they have two particular tools available to the practitioner that they can use to go ahead and reassert their arguments. Motion to re-argue and the motion to renew. Motion to re-argue, you're saying, hey judge, you didn't get this right, this is why you got to get this right. The motion to renew, you're saying, hey judge, these new facts came in, this new information is available, and may or may not have been, if it was available previously and now you're just getting to it now, you got to prefer some kind of reasonable excuse why that happened. But for the most part, it's really best when it's just new information or new acts have happened, and then you want to bring it up like that. So that is going to be this video here today. It's a very helpful tool that the courts offer for you, and that you should definitely take advantage of it if you feel that, let's say you get no shot at the apple. If new things happened after one of your motions or your order to show cause, after one of your papers got dismissed, what the case is, and it's a good tool to have to help you in your mission to be able to secure the best results for your client, so you certainly should consider it. So that's the purpose of this video, just to walk you kind of through motions to renew, motions to re-argue, and their availability. And if you have any questions, obviously we're here all the time. You can certainly, leave them you can email us, you can leave them in the text and messages below, you can text me, I don't really care, always available. So have a great weekend. Hope your New Year's was something special, and yours and Lord's love and lifts, and while I'm here, I might as well get a lift in.